Hello, I'm 𝗪𝗆𝗆, founder of Starlit Contracts, where we help you to negotiate and use contracts with confidence. This video is part of our Build the Foundation in Contracts program, and our topic is the sole and exclusive remedies clause. Let's look at this topic in summary now, and firstly, what is a sole and exclusive remedies clause? Well, it's a clause that's included in the contract with the intention being that a remedy for a certain trigger event will only be those that are set out in the contract. To put it another way, if a contract party would potentially have remedies that are different to those that are described in the contract, when there's a sole and exclusive remedies clause, that would generally mean that they would not be entitled to claim those other types of remedies. It's common to see sole and exclusive remedies clauses inserted several times in a contract. So for example, you might have a general statement in the contract that all remedies described in that contract are intended to be sole and exclusive, but you might also see this statement specifically under the warranty obligations and under any arrangements for the payment of liquidated damages or penalties. Is this something that you should care about? Well, the advantage of a sole and exclusive remedies clause is it means that the parties are clear and can identify what would be the remedy available to one of them if there was a certain trigger event. If you don't have that sole and exclusive remedies clause, what that means is that the party to the contract can potentially claim remedies that are not described in the contract, so it becomes a little less predictable about what would be the outcome if there's some breach of contract, negligence, or other disagreement between the parties. Let's look at a practical example together now. Defective Product Supplier Limited entered into a contract with Customer Limited. Supplier initially attempted to repair the product, but had to replace it soon afterwards, which was very expensive. The product is now working properly. Customer now claims financial compensation for their losses for the period when the product was not working. What could go right for the supplier in this situation? Well, let's say that the supplier and the customer agreed that if there was a defect in the work that the supplier provided, then the supplier would try and repair that defect. But if they were unable to repair it, then they committed to replace the product in its entirety, and that this remedy arrangement for the customer would be the sole and exclusive remedy. Now, if that was agreed between the parties, it would mean that once the supplier had tried to repair and then did in fact replace that defect and provided that value to the customer, then the customer would not be entitled to claim compensation in addition. What could go wrong from the perspective of the supplier in this situation? Well, if the parties did not agree to have a sole and exclusive warranty obligation, that would mean that the customer could pursue compensation against the supplier, potentially up to the value of any liability cap that applies in the contract. This could make the deal a really unprofitable one for the supplier. Let's look at a sample clause and some key considerations now. And firstly, with the sample clause. The rights and remedies in this clause or in the agreement are sole and exclusive and exclude any right or remedy that may otherwise apply under applicable law. Now, one option is just to include this statement once in the agreement and to specify that the remedies described in the entire agreement are sole and exclusive, but it will often be the case that where you have an obligation under the warranty or for liquidated damages or penalties or some other remedy regime described in the contract, that you would want to specifically identify that that remedy for that event would be sole and exclusive. This is to make the contract that much more watertight, to ensure that, especially as a supplier, you're not being exposed to remedies beyond what were anticipated at the time that you sign that contract. Now, when the parties agree that the remedies described in the contract should not be sole and exclusive, or, especially if you're a customer and you're producing template contracts to send out to your suppliers, you might just omit this language. Do not include it. It then becomes the responsibility of the other party, if they're aware of this risk, to include the sole and exclusive remedy language if it's something that they decide is important to them for that deal. I hope that this introductory content is helpful for you, but if you're ready to use a law firm or to hire a lawyer, then go to our website starlitcontracts.com, where we will help you to find the lawyer that you need to address your requirements. See you there.